Good afternoon and welcome. My name is Tunisia Owens, and I am the Policy and Advocacy Manager at the Family Violence Law Center. And we are here to discuss safety. We have a program this summer to talk about various aspects of safety. And this week, we'll be talking about legal avenues of support for survivors. And we have our policy team who are here to help support myself, the Policy and Advocacy Manager, Sadia Khan, the Campaign Coordinator, and Feroz Anir, the Policy Advocate. Some of the topics that we'll be tackling this summer include digital safety, commercial sexual exploitation, and of course, legal avenues that can be taken by survivors of domestic violence. Clearly, our communities have been deprived of resources and the education needed to ensure safety for themselves and their families. With this series, what we're trying to do is disrupt cycles of abuse and start to open up conversations about accessibility, about what safety, public safety really means, how homelessness and how that is related to safety, as well as how we all can join together to make our communities safer. Obtaining knowledge is one of the most important instruments of protection, and these webinars serve as a pathway for a better shared future, education, and empowerment. The agenda for today includes introductions of our panelists, the panel discussion, questions from the audience, and a closing so you can hear about more ways to get involved in making your community safer. The Family Violence Law Center is an organization situated in Oakland, California, that helps diverse communities in Alameda County heal from domestic violence and sexual assault, advocating for justice and healthy relationships. We provide survivor-centered legal and crisis intervention services. We offer prevention education for youth and other community members, and we engage in policy work to create systemic change in court and in our communities every day. This first conversation about safety involves legal avenues of support for survivors. One of the many ways that survivors can protect themselves and their loved ones is through our legal system. The state of California has a robust set of restraining orders that allow survivors of various forms of abuse to seek protection throughout this state. In this webinar, we will explore some of those restraining orders and legal avenues and other types of legal support that can be accessed by survivors of violence. Our two experts will talk to us today about these legal resources. Our first expert is Nicole Britton Schneider, who is a senior staff, who is the managing attorney at the Family Violence Law Center in Oakland. Nicole has 5 years of experience providing direct legal services to domestic violence survivors and their children. Nicole provides free legal representation and paperwork preparation for survivors in civil restraining orders and related family law matters for domestic violence, stalking, and sexual assault survivors across Alameda County. She serves as an advisor to student survivors pursuing Title IX complaints through UC Berkeley and co-supervises FVLC's legal internship program. Prior to working at FVLC, Nicole worked at Family Law Advocates Law Group as an associate, Bay Area Legal Aid in San Francisco for their Economic Justice Project, and at the Bar Association of San Francisco as the Justice and Diversity Center's Diversity Pipeline Program Manager. Nicole holds a JD from Northeastern University School of Law, where she received the Esteemed Public Interest Law Scholarship and has a BA from Cornell University. Welcome, Nicole. Carolyn Kim is the managing attorney at Justice at Last, a nonprofit law firm that specializes in legal advocacy for survivors of all forms of human trafficking located in the greater Bay Area of Northern California. Before joining Justice at Last, Carolyn was the senior attorney and program manager of the Coalition to Abolish Slavery and Trafficking National Training and Technical Assistance Program, providing comprehensive support to service providers working with trafficking survivors. Before joining CAST, Carolyn was a staff attorney at Bay Area Legal Aid, located in Richmond, where she represented survivors of domestic violence, sexual assault, and human trafficking. Carolyn has also worked as a family law attorney at Asian Pacific Islander Legal Outreach in Oakland, and prior to joining Bay Area Legal Aid. Carolyn graduated from Santa Clara University School of Law and the University of California, Berkeley. Welcome, Carolyn. And now we will have our panelists talk to us about and answer some questions. So I'd like to first ask Carolyn to talk about to unmute and talk to us about some legal supports that are available to survivors of gender-based violence.
Yes, I think there are a variety of legal supports, and I'll list some, and Nicole, feel free to also chime in. But I think the most prevalent protection through the legal court systems are different forms of protective orders, right? They're definitely ones where a survivor can initiate the process themselves, called the domestic violence restraining order, through the family law court, where the survivor has more control over the system. But there are other types of protective orders, like in the criminal side of things. There are criminal protective orders which are routinely issued if there is a criminal case open against the abuser perpetrator. And there are also emergency protective orders that can be issued by police officers if an incident happens and a survivor calls and police get involved. The police can contact the courts and get emergency, temporary, really short, usually like 5-day protective orders called emergency protective orders to allow the survivor to go and get long-term orders, usually the domestic violence restraining order, to be put in place to be able to protect themselves. And I think these types of protective orders are available for domestic violence or gender-based intimate partner forms of abuse, as well as human trafficking. So these are orders that are available for all forms of violence.
Thank you, Carolyn. Nicole, can you give us your perspective on unmute and give us your perspective on some of the legal avenues and supports that are available to various forms of gender-based violence?
Certainly. Thank you so much for having me. And yes, to echo a bit more about what Carolyn was saying in regards to the domestic violence restraining orders, there are additional protections and additional remedies that can be requested in those, that can be more holistic in some respects. So there's areas of like custody and visitation that can be addressed in that, financial type of protection related to child and spousal support if needed. There's also housing related protections, in that there's like kick out orders that can be requested. And the work that we do here, a lot of times survivors may not necessarily believe that a restraining order through the court is the safest path for them. And we come from a client empowerment and trauma informed model. So sometimes we'll have consultations with clients or who decide that they may want to seek remedies from the court related to custody and visitation. And that can be a form of protection there, because there are parameters that can be put in place potentially through court orders around the type of contact and communication the parties may have tied to custody and visitation itself. We also do Title IX cases. So sometimes what we see predominantly are student survivors in UC Berkeley, and they may decide that they do not want to go the route of civil restraining orders through a court process. So sometimes they can go through their respective university through an adjudication process in that regards. Now, any um, agreements or issuances that are ordered through the university is not something that is in a civil court. But if, for example, it may order the person who caused harm, the respondent, for example, to have certain stay away orders around campus that would allow the complainant survivor to feel protection in that regard. So, yes, there are legal remedies through the family court as well as criminal court, but we also speak with clients about other options too that may not necessarily be through court itself.
Can you explain a little bit more about those other steps that survivors might take to protect themselves that are not through the court system?
Sure. I can jump in of that if that's okay. So again, as mentioning, we want to be mindful of meeting the survivors where they are and respecting and understanding that the survivor knows better than anyone else the person who is causing them harm, the abuser. And so in our agency, we do initial intakes at the offset where our crisis intervention specialists advocates. And so part of it includes safety planning. So that specifically is based on the client's individualized needs and circumstances, and having a conversation around what mechanisms can be put in place that can potentially ensure that they're safe in some form or capacity. So that may be, for example, if they're getting harassing calls from the other side, is it a conversation about changing your phone number, blocking the numbers? These are just initial preliminary steps. Um, Again, sometimes working with survivors, a restraining order at the end of the day is a piece of paper. And so part of it is going to be a question of whether the respondent is truly going to comply with such orders. And so it may be a situation where a survivor doesn't think going a restraining order route is the best. So we'll have discussions with them around that of, okay, is it a situation of getting court orders around custody and visitation that may facilitate um, that process. Also, it's part of it too, and being safe is having a network of support. And so asking the survivor if they have a safety net of community members or family members, etc., that can be part of the process of gaining that independence from their abuser. So it's more of a holistic approach that we try to take with our the clients that we work with, because at the end of the day, legal remedies may not be the full result in their journey of having that safety.
And if I can kind of add on, in addition to the safety planning, I think it's super crucial, like just chiming and piggybacking off of what Nicole is talking about, that I do think that both of our organizations really try to focus on centering on the survivors because they know their lives the best and they know what is going to ultimately work for them and what's going to be the safest for them. And sometimes it's about making sure that we are clearing out the other noise so that they can really hear their own voice and be able to like articulate what it is that is going to be and what's going to work for them. And so in addition to the safety planning, I think the other larger components is making sure that talking a little bit more about that safety, the robust safety network, is also letting them know that they have access to various other resources in terms of community support, right? And oftentimes a survivor of domestic violence or human trafficking, the largest component of stability is this, concern about financial stability, housing support, right? And these are so crucial to make sure that the survivor has information, right? In addition to those things, if you are a foreign national survivor, oftentimes there's fear about your legal status, your immigration status. And so I think it's really important to make sure that the individual is receiving as much information about the resources that are available if they decide to leave, as well as the legal rights that they are entitled to. Oftentimes, the abusers or traffickers utilize these vulnerabilities to manipulate and control and lie to keep the person in the, a violent or abusive situation. And it's really important to empower survivors to know that they have rights, that they will have access to protection if they choose to move forward and leave that exploitative or violent situation. And so I do think it's really important for organizations like ours to be able to continue to provide information and support that's holistic and comprehensive, right? So it's not just the legal remedies, because as Nicole said, that's, it can only get you so far, right? But it's this idea of building community support and having a community response to support survivors. I think that is really crucial and has been most effective in the cases that I've been involved in.
Thank you for that, Carolyn. If I could follow up a little bit with you, can you talk a little bit about some of the different legal challenges that might be experienced by survivors of trafficking versus survivors of sexual assault, domestic violence, elder abuse? What's different when you're dealing with trafficking?
Yeah, that's a great question, Tanisha. I think the biggest difference is this component of self-identification. Oftentimes, it's not a trafficking survivor that comes and identifies. It's like, oh, I'm a human trafficking survivor. It's not as obvious. And part of it is that our legal definition is broad, right? And so oftentimes we have individuals self-identify as a sexual assault survivor, or domestic violence, or elder abuse. And then it's in conversations with the, a advocate or a trained first responder where the person is then identified by a third party that, oh, this sounds like you may also be a trafficking survivor. And so the lack of identification, I think, is the hardest kind of barrier, right? Because there are specific forms of relief for trafficking survivors, but you would have to first know that you are a trafficking survivor to understand what legal remedies you are eligible for. And so I think identification is kind of one of the big things, but navigating the court system, I think there are different challenges in the level of awareness of what is human trafficking. I think there's this idea in the media about like what is, human trafficking. It's like the Taken Hollywood version, right? And so I think survivors themselves are facing this challenge within the court systems and within like agencies if they're trying to get support, right? If the person isn't trained about what is trafficking and what trafficking can look like, there could be this preconceived notion of this is what a trafficking survivor looks like, and you don't fit that definition. So oftentimes we're working with a lot of survivors that have past like trauma from or like systems not recognizing them at their victimization, not viewing them and providing them support. So, and in addition to that, we have a lot of, it's very common for survivors to be forced to commit crimes by their traffickers. So in addition to not necessarily appearing physically, like you don't make the description of what that Hollywood has classified as a trafficking survivor, now on top of that, you have a criminal record because your trafficker has forced you to steal goods from like the stores or to like sell drugs, right? And so now you're walking into any legal system with this stigma that you are a criminal, right? Even though it was forced, and you would have not done that if you weren't forced to do it, against your will, right? And so I think there are just definitely challenges both in particularly, I think, in the family law court where there's custody matters involved. Sometimes judges don't understand, and sometimes in situations when the other parent in common is the trafficker, they're using the past criminality in the court to describe why this person is not a good parent, right? And the court systems don't necessarily have a thorough way to be able to understand, wait, like, are you not the trafficker that forced this person to commit these crimes, right? And sometimes it's extremely hard for an individual to navigate that, particularly without representation, if they haven't even identified themselves as a trafficking survivor. And so I think, these are the top things that pop to mind in terms of some of the barriers and difficulties that trafficking survivors may have.
Thank you for that, Carolyn. Nicole, did you want to follow up on any of that and include information about how survivors of domestic violence might face some of those barriers and challenges, but that may be a little bit different from, let's say, sexual assault, elder abuse? So what are some of the differences in the legal experiences of survivors of domestic violence?
Yes, certainly. Some things that immediately come to my mind as challenging in navigating the legal system is that, quite frankly, it's not a very trauma-informed and survivor-centered process. The domestic violence restraining order process automatically can be an uphill battle. One, you have like numerous forms, 20 plus pages of forms that need to be filled out. They're all in English. So you already have a language capacity issue and access, and survivors who may not be English native speakers or able to read in English, there's already a barrier there. Another challenge in the restraining order process itself is the service piece. So, as part of being able to proceed in a restraining order matter, generally speaking, the respondent has to be personally served. So, a lot of times, survivors are dealing with abusers who may be homeless and transient. They may be trying to what's the word? Try to um, avoid service in some ways. And there's also the financial implications of hiring a process server or getting someone served. So there's a barrier with that too. For example, the sheriff's department can do service, but it only is during business hours and it has to be at an address within Alameda County. And you have survivors who are dealing with abusers who may not be at a residence at business hours. They may be working. So there's also barriers with that. The restraining order hearing itself, quite frankly, is not trauma informed. It is requiring the survivor to retell their story in a very high intensity, high stressful situation. They're basically in a public setting because it's public and it's court, so other people are having their matters heard, and it's a very limited time frame. Usually, the short cause calendar is 20 to 30 minutes that a judge is going to take to hear your matter. So, if you can only imagine having to endure the physical, to endure the abuse, and then having to see the person who's caused you harm, which is another thing that survivors may not realize, that the abuser can choose to show up. And so you're literally retelling these stories in front of your abuser, being grilled in some ways by the judge as well as opposing counsel if there is one. And then family court services with mediation. That is a challenge as well. You're only given about 15 minutes where a third party who has no idea about what you're experiencing is basically making recommendations about temporary custody and visitation orders. And so it's a very, I would say, like revolving door kind of process that is not very trauma and centered and survivor centered. Um, so those are some of the immediate things that come to my mind. Also, challenges include the enforcement. Again, it is just a piece of paper. So part of it is going to be if a respondent is actually going to respect court orders. Now, the court has taken measures, especially with gun compliance, to schedule compliance hearing dates to ensure and make orders that respondent turn over firearms. But unfortunately, we see a lot of times respondents who repeatedly violate the restraining orders. Survivors are making police reports and nothing is essentially being done. Part of that is because the process for prosecution is based on the district attorney's office. So that's something separate that the survivor has no control over. That's not to deter survivors from seeking restraining orders because it can be helpful in some respects. But survivors, I think, as far as having the information and education, need to be aware of like the challenges that will be in play with going through that process because it's not as straightforward or simple as it may seem.
Nicole, I'd like to follow up on that. In some ways, you're really highlighting the the limitations of some of the legal frameworks that we have available? Are there some spaces within those legal frameworks that might be expanded or might be more helpful for survivors?
Certainly. I mean, there is the opportunity within like the restraining order process, and I think a positive aspect about it is that with the domestic violence restraining orders, it's the survivor essentially in the driver's seat because they're the ones that are able to petition and ask the court for what they're requesting. Um, it's it's a challenge in some ways because we want to be mindful of the dynamics of power and control, and having the abuser not use the legal system as a form of further manipulation or further power and control over the survivor. However, with that being said, the survivor does have the autonomy to at least let the court know what their thoughts are as far as what they're requesting. So there is a possibility if a survivor determines that maybe the restraining order route is not necessarily the route that they decide that they want to take for whatever reason. They can potentially reach some type of stipulations or agreements with the other side, obviously through the court in those respective hearings. Um, so there is opportunities for survivors and room around that. I think what's interesting though is that some survivors may want a more restorative justice type of approach where they're able to at least have the recognition from the abuser of the harm that they caused and what was done to them and that they were wronged. While that makes sense from like a more emotional and like survivor and centered and like empowerment model of what the survivor needs. That's a challenge though in like a civil restraining order type of matter because that's not something that the court is given the authority to do. So I've seen in some situations where survivors, that's all they wanted at the end of the day, and having to explain to them, well, that's not necessarily the remedy that is provided in the restraining order matter or the restraining order process. So there's a lot of room for growth. I think too, part of it is continuing to see the education of like the bench officers who are handling restraining order matters. Technically, judges are supposed to have like bench officer trainings around like DV and things like that. But certainly, my hope would be to have like more education from the bench perspective around the understanding of the dynamics of abuse and power and control and things of that nature.
Thank you, Nicole. Carolyn, I'd like you to reflect on those legal frameworks as well. And we have a question from the audience. So if you can both reflect on some of the limitations that we've talked about and how we can expand, but also address this question. Are there any ways to expunge criminal records of a trafficking survivor who was forced to commit crimes?
Yes, let me answer that question first, and then I'll go back to like the overarching question. So yes, there are in California, the post-conviction relief process is called vacatur. And what's super exciting is that now this form of relief is also extended to domestic violence survivors as well. And so what is really great about the vacatur process, which is different than the expungement process, is that it is the criminal court's recognition that this person shouldn't have ever been arrested in the first place. And so as a kind of form of relief, the court has decided to completely destroy all the records, right? And the legal standard of getting that isn't based off of rehabilitation. Whereas in the expungement process, right, it's more like the criminal defendant has gone through, served their time, they've understood that they've done wrong, and they are a different person, right? And they've rehabilitated, and you have to show proof of that, right? Whereas the vacatur process is focused, the philosophy is different, right? It's not that you are a criminal and you've served your time. It's that you were forced to commit these crimes in the very beginning, right? And so it is the court's way of recognizing their error and completely destroying all records. And so it's as if that crime or the conviction was never happened. And so it completely erases everything, right? So when you go and fill out applications, if it asks, have you ever been arrested or convicted? You can say no, even in immigration proceedings. That's how the California vacatur relief has been designed. And it has definitely expanded now to domestic violence survivors as well. So as long as a human trafficking or a domestic violence survivor can prove that it was a non-violent offense that was committed as a direct result of their exploitation or their abuse, then they are eligible for this relief. And it definitely has been a game changer in terms of removing barriers and a healing process for survivors. We've definitely seen trafficking survivors that we've worked with talk about how they feel more whole and more heard because they were able to go through this process. It's, like Nicole mentioned about the restraining order process, the vacatur process is also survivor driven, right? So the survivor, it's an opportunity for the survivor to tell their side, to explain why they were victimized and how they were forced and how they were wronged. And once the court grants this, and it can happen with or without a hearing, it's like a recognition that the person was a victim, right, and shouldn't have been arrested. And I think that has been really powerful for survivors, and it's been really wonderful as an advocate or a legal attorney to witness that. And so, yes, there are ways to remove these criminal records. And then in terms of the question in how can we just kind of thinking about these legal frameworks, where can we do better? How can we create growth? The one area that just popped into mind as Nicole was talking was this idea, right? Of there's so many restraining order violations, for example, right? But our criminal legal system has limitations, right? And so one of the areas where we've been routinely practicing in is crime victim rights. And so in instances where there have been, for example, multiple restraining order violations, right? And the district attorney ultimately has the authority, and they're the ones that decide which cases get prosecuted. But we've definitely seen more success in being able to get more effective adjudications or prosecutions when a crime victim rights attorney whose sole interest is focused on that survivor and what enforcing those survivors' rights. We've definitely seen a impact in that criminal legal process, right? And we've definitely seen crime victim attorneys be able to not only assist in situations where we are highlighting for the DA why this case is so important, why these violations are so egregious, right? Because it's human nature that there's so many cases, right? And so having effective crime victim rights enforcement, I think, and representation has made a difference in making sure that survivors have a voice in the criminal legal system. Because right now, currently how it's designed, it's kind of more like we have the prosecutor who's upholding the either the state or the federal interest, and then we have the criminal defendant, but we haven't really carved out a space for the individual that was actually injured. And we've definitely seen more healing and more accountability placed when a survivor is able to meaningfully participate and be involved in the process to not only find healing for themselves, but to enforce justice and enforce order of law. Because ultimately, at the end of the day, all of these acts of violence, we've identified these as a society as crimes, right? And it's a crime against public safety. And so if we are thinking about areas of growth, I think in addition to all the things that, Nicole has talked about, I highly agree, this entire process, all the legal processes are very not trauma informed. But I think one area of growth can really be looking at our crime victim rights. This is in California, it's a constitutional right, right? And how are we effectively utilizing this and really making this right accessible for survivors?
Thank you for those insights, Carolyn. We really appreciate it. Nicole, we have a question from the audience that I'd like you to answer. And then I have a second question, but I'll let you answer this audience question first. And it says, how can survivors protect themselves beyond the limitations of the expiration of a restraining order?
So just to be clear, if it's a situation where a restraining order has expired, that doesn't preclude a survivor from applying for a new restraining order request. So that opportunity is still afforded to them, like if there are new incidences that have occurred. And we certainly see that, unfortunately, because of the cycle of abuse, that sometimes survivors may have gotten a restraining order after hearing and they either may have reconciled with their abuser and the abuse has resumed, or their for whatever reason their restraining order expired and then new incidences occurred. So there is that opportunity to request a new restraining order if new incidences have started. Additionally, that goes again back to I think the holistic approach of client survivor safety. So again, reaching out, I would suggest to DV agencies, for example, such as Family Violence Law Center, where there can be some discussion around safety planning around it. Additionally, to looking at the holistic situation of, well, what other barriers or issues may be coming into play that can provide like referrals or support so that survivor can have that independence and protection away from their abuser. So again, there might be legal remedies available, but also the social like services type of support is also there too, and having those resources identified.
This is a question that I'd like both of you to address, but what are some of the things that you want survivors to understand about seeking legal services and legal protections? And, or what do you think survivors should know before they engage the legal system? So, what do you want them to understand about legal services and protections? And, what should they think about before engaging the legal system? So, Nicole, I'd like you to answer first, and then Carolyn.
Sure. What I can say that I've done with speaking with clients and our team has done is setting realistic expectations for the survivor, and so letting them understand what the process itself entails. And that's the challenging aspects too. So as I mentioned before, what it's going to take in a courtroom setting to get a restraining order, what the judge is looking at, being prepared that you will likely see your abuser in court literally right next to you, and having to convey the incidents that have occurred. Also, another thing I like to tell clients about is just realistically what the purpose of the restraining order is and what remedies can be um, done through that. So, a lot of times there may be underlying issues such as like property and divorce, for example, that may be down the line, and so it's not appropriate necessarily in a restraining order to be going over like the division of assets because a judge is not going to really touch on those things. And so having to set those realistic expectations with clients um, is helpful. I would say too, again, the service piece is a challenge. And so sometimes survivors can be frustrated, rightfully so, that they went through this process, but they haven't been able to serve. And just explaining to them what requirement is and seeing if we can brainstorm creative ways of trying to figure out how to serve the other side. Um, so and I think lastly too, just expectations around enforcement. So for example, there may be violations of the restraining order pertaining to like custody and visitation. And so sometimes a respondent can be like late for a period of time. And so just having the conversation with the client of like, yes, you know, you can certainly make a police report about violations, but depending on the type of violations, is it going to be something where the police are going to arrest the respondent for it, or is this something more where it's a longer term issue of like custody and visitation that may have to be adjudicated through multiple hearings through the court. So those are just some initial things that came to my mind.
Thank you for those insights, Nicole. Carolyn, do you have some things you'd like to add?
I think everything that Nicole touched upon can really be expanded across the board through various legal channels, right? So all of the difficulties that Nicole has listed, from service, right? Really being able to serve the other party, right? I think it happens in both the civil side as well as the criminal side. And then, you know, the process more like the legal process itself, like whether you are named as a crime victim witness coming in to testify in a criminal trial against your abuser trafficker, or whether it is a civil case that you're pushing forward because of lost wages, right? If you're talking about labor exploitation, these are all cases where the legal process can be long and drawn out, and it's not immediate. It's not like I file this and I'm going to get this the next day, right? It's a long process. And then in addition to that, oftentimes there are components of having to face the perpetrator, abuser in court, as well as that being grilled. I think Nicole said it. I think that's the exact kind of feeling that the person has to kind of get through this interrogation almost process of telling what happened, and, you know, especially if it's in front of a jury, right, which is different, a little bit different from the family law process. But in the criminal case or in a civil case where a jury of your peers they're the ultimate deciders, right? So it's a very intrusive process that is not really designed to be quick or easy. And I think setting these expectations are really important, so that the person understands and can make that informed choice about what they want to move forward. And I think that last piece of enforcement, I think across the board, like it is something that we go over constantly about, you know, the legal remedies. Oftentimes, for example, a crime victim is, especially for a trafficking survivor, they are eligible for mandatory restitution, right? But I think that language is tricky. I think, you know, the judge may be mandated to order restitution, but the actual enforcement of getting restitution, the monetary compensation for the injuries that they suffered, that is an entirely different thing, and it's not guaranteed, right? So I think it's really important having these conversations on the offset or on the onset, and asking them, what is your ultimate goal? And asking survivors to really define, like, what is it that you're looking for healing, or what is this, you know, sense of justice? Like, you would feel like you obtained justice if you were able to fill in the blank, right? And oftentimes through the conversations, like Nicole has mentioned, it's being realistic about what the limitations are about these legal systems that are in place, and then looking to see if there's alternatives to be able to get what the survivor is actually looking for, that may be not as intense, or not met with the same barriers as some of the traditional legal remedies that we've kind of discussed today. So I think that's kind of the biggest kind of thing for survivors, that it's like they have ultimately the choice and agency, right? And I really encourage a survivor who's in that situation to ask questions and to figure out for themselves, like to be able to clear out all the noise from everybody else telling them what they should do, and really, you know, trust your intuition about what it is that you want and you need, right? So I think that's kind of my 2 cents.
Well, Carolyn, we have a question from an audience member. And actually, they'd like both speakers to speak to this, but we'll have Carolyn answer first. What protections does California have for survivors of abuse and or trafficking when the abuser is located outside the state of California, but is still causing harm within the state of California? And how might we be able to protect ourselves from this?
Yeah, I think this is a complex question, and I think it really depends on what type of harm we're looking at. And I think there's a legal answer, but there's also like the social services safety planning aspect of it, right? So I'm not an expert in safety planning, so I'm going to just highlight that that is something that we and if you haven't already talked to a case manager who has a lot of different resources about how to keep a person safe, like I just want to highlight that that's a resource that is definitely available. And in terms of the legal aspects, I think it just kind of depends. I'll let Nicole talk about more of the restraining order process and the enforcements and limitations there. But for a trafficking survivor that's dealing with this, oftentimes, if it is in a different state, it just kind of depends. Like, for example, I've been like, there's been situations where a survivor is a witness and is going to testify against their traffickers, and they are being harassed by either the trafficker themselves or an accomplice or an affiliate of the trafficker, and they're out of state, right? In those situations, there's usually a criminal protective order in place, and we notify the prosecutor right away, whether it's the district attorney or the AUSA, if it's on the federal case. We let them know right away that this is happening, right? And so these are criminal, it's a violation of the criminal protective order. And so oftentimes there will be interagency law enforcement support. So if we can find out where the person who is causing the harassment or causing the harm is located, that we'll be able to kind of work with either FBI agents, or if it's on a state level, like local law enforcement can reach out to other law enforcement, and we will kind of go through in terms of trying to enforce the protective order, and sometimes add people onto the criminal protective order if they're not already listed. I think it's kind of one area. The other thing that I'm thinking about are like, a lot of this is, I think, also part of the restraining order. So it's oftentimes we have people like post videos or things like that where they're operating from a different state, or there's like additional enforcement. So oftentimes we'll need to go through, in addition to having criminal protective order, we may also get a restraining order, whether it's a civil harassment or a domestic violence restraining order, to enforce it that way, to add additional orders in to stop certain behavior, to be able to enforce it that way. But I'm not going to get into the nitty-gritties of that because I'm going to let Nicole talk about that piece.
Yes, thank you. It's definitely it's a legally technical question, because what I can say for examples that we have seen in situations like that, the concern is that with the domestic violence restraining order, the court needs to be able to basically have the authority to make orders against the respondent. So long story short, the respondent needs to have some type of tie to California, whether that's and the county specifically that you're filing in. So whether that's that the respondent lives there in that particular county, which doesn't apply in this situation, or if the incidences of abuse that are alleged happened in the particular county. And so, what we would do in a situation like that is need to know more about what are the actual instances of abuse, what has been occurring. If it's more of like an electronic type of situation, that may make it a challenge in being able to file it in California, because the court may determine that they don't have the authority to make orders against the respondent. And so, in that situation, we would do a consultation with the client and also hook up the client with our advocates to do, again, more of that high level safety planning type of discussion with the survivor. I will say though, what's very helpful in restraining order matters is that clients keep documentation of the incidences of abuse that have been occurring, because then that can create a good track record, if you will, if the opportunity presents itself where a survivor wants to request a restraining order, they have this additional evidence and support. Now, that's not required for a restraining order. The court can determine granting a restraining order based on testimony of parties, but having that additional evidence can be quite helpful. So it is more of a technical question, but that is something we do see. And sometimes it may be situations where we will advise the survivor about potentially contacting a lawyer at the particular state that the respondent is located in to see what remedies legally they have there. Because it may be that they have to file a restraining order there, which is not convenient, of course, but that may be an area that they can utilize.
We have another question from the audience for both speakers. And so, Nicole, I'd like you to answer first. And this is a racial equity / cultural question about creating feelings of comfort in the courtroom. How does our organization work with survivors to make sure that they feel comfortable in the court, particularly if they come from a culture where it is taboo to seek justice against your partner? And then another part of the question is, are there mental health services provided by our organizations and aftercare? So does our service extend beyond the court interaction? Do we provide mental health care? And then how do we address cultural issues with our clients?
That's an amazing questions, I should say, plural. And yes, so I'm speaking as like the attorney wearing the attorney hat on and how I work with my clients. The first issue is ensuring that there's no language barriers, right? So in restraining order matters, we represent survivors who speak a variety of different languages. So immediately, I would want to make sure we request an interpreter in the language that the survivor speaks, so that way the survivor has the interpretation there so that they can understand what's going on. And so sometimes that can cause delays with hearings, but that's something that the court is obligated to provide if requested. So that's one thing we do. Additionally, I like to speak with my clients in advance of the hearing to let them know what is to be expected, so that they have at least a sense of what they're getting into once we get to court. Because quite frankly, knowledge is power. So at least knowing what is anticipating what may happen, I think is helpful. A lot of times what I've done and what our team has done is we will have an advocate possibly join us at the court hearing to provide that additional support. Or we may ask the survivor if they have a support person that they were thinking of bringing with them. Certainly, conversations that we have with the survivor are privileged, and so that support person won't be present. But if in any way it can alleviate the concern that the survivor has, and give them a sense of calm in the midst of this really unexpected, scary process, that helps. Um, and then as far as the like comfort and taboo and cultural stuff that was mentioned, a lot of times we like to make sure that we refer clients out to other partnering agencies. So, for example, what immediately comes to my mind is that we may have like a mom speaking survivor, or we may have a client of a specific dialect or a specific culture, right? And so if we can find referrals for other community partnering agencies that may be able to assist that survivor too, and see if we can like cross collaborate and partner, we've done that as well. As far as the question about mental health services, we as an agency don't offer the mental health services. We do have a therapeutic program where, for survivors who either are in Oakland or the incidences of abuse or were in Oakland, if they have children 5 and under, there's a didactic therapy service that we offer with the survivor parent and the child. Um, so that's free of charge, and we offer that. But if they don't fit into that, our advocates will provide referrals to agencies that may offer that service. So we do our best when a survivor is identifying a particular need. If we are unable to accommodate it, we find an agency that may be able to assist. So hope that answers the question.
And then in terms of justice at last, I think just to add on to what Nicole was saying, I think in terms of the cultural implications in the courtroom, if there are, and we've definitely seen this where the bench themselves need a little bit more educating about a particular culture if they're not familiar with it. And oftentimes for the work that we do with trafficking survivors, there's definitely a lack of understanding about trafficking. And so we definitely try to file briefs ahead of time to educate the court a little bit more, give them advance warning about like these are culturally sensitive topics, right? And this is how this ties into this idea of trafficking or abuse, right? This is the form of coercion and making sure that the court has this information on the offset, so they're not, or on the onset, so they're not caught off guard or asking intrusive, overly intrusive, or that the judge has the ability to determine like what is the appropriate level of questioning about certain subjects. So that's kind of the first thing. In terms of the supportive services in the courtroom for the survivor themselves, we've definitely have gotten feedback and from survivors who've gone through the process about how important it is to have like an advocate present and a part of their kind of journey if they choose and they want. And so at Justice at Last, we've intentionally designed our program so to include client advocates, and these advocates are non-attorneys, but they are covered under our attorney-client privilege. So they are supporting with emergency crisis stabilization throughout the legal proceedings to allow the survivor to meaningfully participate through legal proceedings. And so this has really allowed the client advocates to get full access to the information as well as provide the needed like trauma-informed services, grounding techniques, whether it's during the interview process, in preparation for the court hearing, during the hearing itself, or afterwards. And so some of the things particularly that I kind of want to highlight right now is like if you are a survivor who is going through a criminal proceeding and you are called to testify, you've been subpoenaed, one thing that we make sure that we always do is request the support person to be able to go with you and be there as you are testifying, so you're not alone. And in most cases, we've been pretty successful in having the support person be able to sit right next to the survivor as they're testifying. So these are kind of things that, again, thinking about victim rights enforcement, about how we try to accommodate and make the person as comfortable as they can in this very traumatizing situation. And then in terms of mental health access, our client advocates do provide that grounding support. They're not therapists, right? But they do provide that counseling and immediate kind of stabilization support during that entire legal process. So oftentimes we'll make sure that they're there with us during the proceedings. They'll be there with the survivor to kind of prep them during breaks to kind of decompress, and then at the end debrief. And then the other thing that we make sure that we do at the very beginning of the cases is to apply for a CalVCB, which is a victim compensation program that that all survivors of domestic violence and human trafficking are entitled to get access to. And one of the great things about CalVCB is that it also includes free mental health services. And then our advocates oftentimes, once that CalVCB application is approved, we've been able to successfully find culturally sensitive therapists and be able to connect and link them if the person wants additional therapeutic support throughout the process. So that's kind of the stuff that we do here.
We are coming pretty close to time, so I wanted to ask these last two questions. The first question for both of you is, what are some ways that you wish the social service system viewed survivors differently? And so this is our social safety net. So things like child welfare, and child support services, the court system. So all of those social safety net type programs, how do you wish that they interacted with survivors differently, if you could? If you could wave a magic wand, how would you change the way our public service systems interacted with survivors?
I think one part definitely is those particular agencies doing the work to become educated around issues that survivors face. And having it's a challenge because those respective agencies have their own obligations and their own commitments, right, that they need to fulfill. But sometimes, for example, social services or like child protective services may not be informed in realizing that it doesn't take it takes longer than a day to be able to request a temporary restraining order, and understanding what that process entails. um Also recognizing, and I would hope that these different agencies do have the education and are trauma informed, but um at least listening to the survivor and their experience and what they're going through, and not necessarily making threats or giving ultimatums, because that creates a new a repetition of that power and control in some way, but now with a different entity that the survivor had no control over being connected to. So I think what I would like to see and what I would hope is that these respective agencies would make a commitment to at least reach out to agencies that are doing this type of work to understand the dynamics and the barriers that survivors are facing, and come from not necessarily a model of like you have to do it this way, but having an honest conversation about what their requirements are, but trying to understand where the survivor is coming from too.
I think my two things are pretty specific, and I hope it's not to anybody in this room, right? But in general, these are the misconceptions I hear the most from it. And the first thing is that for social service providers to be informed and let folks know that if they are going to get access to public benefits, that there is like something called a DV waiver. I think a lot of the times survivors of both DV and human trafficking are pulled into the family law system because they haven't been told about the DV waiver, and as a result, they think that they have to open up a child support case, and oftentimes that can become more volatile and dangerous for an individual. And so I've definitely have seen like the doors being open and custody battles ensuing, and it's not in the best interest of the child. It's simply because the other parent doesn't want to pay child support, right? And the parent who has custody of the child is needing access to these benefits, and so they I can't talk more about the ability to ask for a DV waiver and how important that is. And then the second thing that I hear misconceptions all the time is that, as a case manager, oftentimes you all have a different relationship and rapport and trust with the survivor, different from a legal service provider. And I think when there is conflicting information from a case manager and a legal service provider, I think that's where I think some of the hardest kind of conversations have to come about, and it really puts the survivor in this position of who to trust. But the area that I'm thinking about that I get the most is that oftentimes trafficking survivors come to my office and they say, well, I was told that since I'm a trafficking survivor, I am going to be able to get full custody of my children. That's guaranteed. Or they'll say that, the other parent is the trafficker. So I was told that that person is not entitled to becoming a parent, so I can terminate parentage. And it's not that simple. I think child custody matters are very complex and very different based off of the facts. And I think that once someone gets into my office, it's really difficult to kind of walk them through if they have this preconceived notion from somebody that they've trusted that they are legally entitled to these things. And oftentimes it's definitely been more, as an organization that's being survivor informed, it's definitely difficult to kind of try to navigate like what is the reality and what is really possible versus like what this the survivor believes is going to be the outcome. And then I think, so one last thing that folks have been told oftentimes is that they need to get a child custody order, right? Like they need to have a court order in place to be safe. And oftentimes that's not the case, especially if the other parent isn't listed on the birth certificate, and it could cause more complications down the line, right? So I think these are legal determinations and that are very different based off fact. So if you all who are listening can also pass on the word that sometimes it's definitely better to allow an attorney to really do that legal analysis and to be able to be supportive in that process, I think is my ask, or yeah. So, but thank you everybody for doing all the great work. Like I definitely can't do the work that I do without my case managers. Like I think you all play such a crucial role with survivors. And I think I've definitely had the opportunity to build up such great partnerships because I'm able to talk to my case managers about this information. And when we come together and we have the same message and we're on the same page, it's really, we can create magic, right? So I guess that's my other ask to also be okay or talk with us attorneys. Like I know that I've definitely learned the most from my case managers.
Well, thank you all. I wanted to give an opportunity for our two experts to give us 30 seconds each on a legal change that you would like to see. So dream big, give us 30 seconds on a legal change you would like to see in California to improve outcomes for survivors. And we'll start with you, Carolyn.
Sorry, I was trying to answer those questions so that but anyways, mine would be to really give teeth to the Crime Victim Rights Bill, to be able to give enforcement mechanisms. So if your victim's rights have been violated, that every courtroom has the ability to step in and enforce those victims' rights so that each survivor is treated with dignity, respect, and fairness in every courtroom.
Thank you. And Nicole, 30 seconds on your big legal change that you would have in the state of California to improve outcomes for survivors.
Sure. I think my big wish or dream would be that there would be court-appointed attorneys for domestic violence petitioners. I think our our court system takes very seriously when someone is facing criminal like prosecution and can appoint them a public defender. If folks are at risk of losing their children in the dependency court, they are usually appointed an attorney. I think our state needs to take seriously gender-based violence and domestic violence and afford petitioners of DVROs the right to counsel that's court appointed if possible.
Well, thank you for that. We really appreciate all the information that has come from our two experts. And I'd like to invite the audience to come back for another Thursday lunch session. I'm going to share my screen and show you the upcoming events. So what we have next Thursday will be policy changes for safer communities. And then on August 10th, we'll be having understanding consent and healthy boundaries. And then our final conversation will be digital safety in our communities. And so we'd like to thank the audience for attending and thank our experts and the team for putting this together. But we hope to see you all next week, and we hope that we were able to answer most, if not all, of your questions about legal avenues for survivor safety. Thank you, and we'll see you all next time.